Aloha and good morning. My name is David Tarnas, and I am the chair of the House Committee on Water and Land. And welcome to our hearing today, February 4th, 9 a.m., conference room 430, State Capitol. We wish you were all here, but unfortunately, because of COVID, we have to close the Capitol to the public, and we welcome you online. Thank you for sending in your testimony. And those who are testifying today orally, thank you for doing that. Please allow me to read just some introductory guidelines for folks who are watching today and participating. In order to allow as many people to testify as possible, there will be a 2-minute time limit per testifier. Because morning hearings must adjourn prior to the noon floor session, not all testifiers may have the opportunity to testify. In that event, please know that your written testimony will be considered by the committee. Please keep yourself muted and your video off while waiting to testify and after your testimony is complete. The Zoom chat function will allow you to chat with the technical staff only. Please use the chat only for technical issues. If you are disconnected unexpectedly, you may attempt to rejoin the meeting. If disconnected while presenting testimony, you may be allowed to continue if time permits. Please note the House is not responsible for any bad internet connections on the testifier's end. In the event of a catastrophic network failure, it may be necessary to reschedule the hearing or schedule a meeting for decision-making. In that case, an appropriate notice will be posted. Please refrain from profanity or uncivil behavior. Such behavior may be grounds for removal from the hearing without the ability to rejoin. Mahalo for participating in today's hearing. Thank you, members, for being here. Let's go ahead and begin our testimony. Consideration of a number of measures. The first one, House Bill 203, relating to a water storage and distribution system for certain agricultural land in Wahiawa, Oahu. We have received testimony, 16 in support and none in opposition. First, we have James Nakatani with the Agribusiness Development Corporation in support. Next, Kalani Franda from Office of Hawaiian Affairs in support. And Kalani Franda is here today to testify. Oh, he is not here today to testify, but sent in written testimony in support. Hinano Rodriguez with DLNR sent in testimony in support and is here to provide oral testimony. So let's go ahead. Hinano Rodriguez, you have the floor. Please proceed.
Aloha kakahiaka, members of the Water and Transportation, Water and Land House Committee. My name is Hinano Rodriguez, and I am the History and Culture Branch Chief at State Historic Preservation Division. Our administrator, Dr. Alan Downer, could not be at this hearing, and therefore I speak on his behalf. First of all, mahalo for the opportunity to provide testimony. Our testimony this morning is that the department stands with its written testimony, which is in support of this bill.
Thank you very much, sir. Appreciate it. Next, we have Brian Miyamoto from Hawaii Farm Bureau in support. Mr. Miyamoto, you have the floor. Please proceed.
Good morning, Chair Tarnas, Vice Chair Bronco, Brian Miyamoto here on behalf of the Hawaii Farm Bureau. The Hawaii Farm Bureau will stand on its written testimony in support.
Thank you, sir. Appreciate it. We have a number of testifiers sending in written testimony in support. I will read them, their names. Diane Fitzsimmons, Wailua Hawaiian Civic Club. These are all in support. Kupuna for the Mo'opuna. Gordon Lindsay, B.A. McClintock, Tadia Rice, Jesse Cook, Johanna Stone, Chloe Amos, Olu Campbell, Noelani Nakasone, Kahialani Acosta, and Alvin, all in support. That's all the testimony we have today. Members, any questions of our testifiers today? Seeing none, we'll move on. Thank you very much. The next measure we're going to consider, House Bill 544, making an appropriation for a capital improvement project at Mauna Kea on the island of Hawaii. This is to provide funds for the removal and decommissioning of Hoku Kea telescopes from the summit of Mauna Kea by the University of Hawaii. We have testimony in support of the in support of the measure from University of Hawaii, Bonnie Irwin. We have comments from DLNR, Mr. Sam Lemo, and Sam has signed up to give testimony. And if he is available, then he would know. Okay, he's not available right now, but he did send in testimony, which basically requests that the DLNR's name does not need to be on the measure because it's the UH that would be the expending agency, not the DLNR. Other testimony, comments from Cheryl B. Testimony in opposition from Catherine Rosaguo, and testimony in opposition from D. Green. That's all the testimony we have today. Questions or comments, members? Among each other, we can discuss, but otherwise we'll go on. Question? Yes. Representative Ganadin.
Is there a cost associated with, as Ms. I don't want to mispronounce her name, Rosagua mentioned, to turn the telescope into a teaching telescope?
Thank you for the question. I did get information from the University of Hawaii about this. This request is actually just for the removal of the telescope, the decommissioning, and not for the recommissioning as a teaching telescope. That would be a separate matter. And so the request here is just for the funds for planning, design, permitting, deconstruction, site restoration, and monitoring. It would be a separate measure that would actually do the commissioning for it at Halepohaku or whatever site the university would recommend. So that's a separate measure.
Would it make sense to put those measures together?
Not from the university's perspective. So that's the university's preference is to do it this way. But I appreciate your suggestion, and I appreciate that was the comments from the testifier. Thank you for bringing that up. Any other questions? All right, thank you very much. Let's move on to the next measure. House Bill 501 relating to water rights. On this measure, we have testimony, I'll just go in the order, from DLNR, Mr. Ian Hirokawa in opposition, and if he is online, then he is available to give oral testimony. Mr. Hirokawa, the floor is yours.
Good morning, Chair Tarnas and members of the committee. Ian Hirokawa with DLNR Land Division. We'll stand in on our testimony in opposition, but be available for any questions the committee may have.
Thank you. Testimony from William Isla of Department of Hawaiian Homelands in support. Mr. Isla, you're available.
Good morning. Good morning, Chair. Can you hear me?
Go ahead. We're not hearing you, Mr. Isla. We see you, but we don't hear you.
Oh, that's good quality. Look at that.
Thumbs up. You're saying yes. You like the.
Turn on the mic.
Okay, so we'll thumbs up. The testimony is in support, and I appreciate that. And we'll move on. Thank you, Mr. Isla. Next testimony from Brian Miyamoto from Hawaii Farm Bureau in opposition. Mr. Miyamoto, please proceed.
Thank you, Chair. The Hawaii Farm Bureau was down on its written testimony respectfully opposing. We believe that the current rational approach for selling water leases should be retained. This may make it uneconomical for our farmers to continue their agriculture operations. Thank you for the opportunity to testify.
Thank you very much. Next, we have testimony from Mr. David Arakawa, the Land Use Research Foundation of Hawaii, in opposition. Mr. Arakawa is not available to provide oral testimony. Members, you can refer to his written testimony in opposition. We received testimony providing comments from Marty Townsend from Sierra Club, testimony from the Waioli Valley Taro Hui, Reed Yoshida, providing comments, and testimony from Charlene Schullenberg with opposition to the measure. Members, any questions? If not, oh yes, Representative Kobayashi.
For DLNR, do you have a alternate amendment or draft?
Yes, we have a different valuation methodology we're proposing, but we're actually proposing to amend HB 1015 with a formal amendment. We're just in our testimony here, we raised the sort of conceptual basis for our rationale, but we're actually proposing the amendment for the admin bill HB 1015.
Okay, so your amendment is essentially in the next bill on the agenda.
Yes, yes.
Okay, thanks.
Thank you.
Thank you, Representative. And that's exactly why we are hearing both of these bills one after the other, because they are related. They represent two different perspectives from the different agencies. And so we'll take up DLNR's recommended amendments in the next measure. Any other questions from members about House Bill 501? If not, thank you very much. Let's move on. House Bill 1015, relating to disposition of water licenses by the Board of Land and Natural Resources. For this measure, we have testimony from DLNR, Mr. Ian Hirokawa. Please, the floor is yours, Mr. Hirokawa. Please proceed.
Thank you, Chair Tarnas, members of the committee. Ian Hirokawa with DLNR Land Division. We'll stand on our testimony in strong support of the measure, and noting as we before our proposed amendment to address the appraisal of water. Be available for any questions that you may have. Thank you.
Thank you, Mr. Hirokawa. Next testimony providing comments from the Department of Hawaiian Homelands, Mr. William Isla. Mr. Isla, are we able to hear you now? You're welcome to provide testimony if so. Does not appear so. Okay, thank you. Please, members, I refer you to the testimony from Department of Hawaiian Homelands, which we do have in our packet. Next, let's move on to the next testifier, Mr. Brian Miyamoto from Hawaii Farm Bureau, providing testimony in support. Mr. Miyamoto, the floor is yours.
Thank you, Chair. The Hawaii Farm Bureau will stand on its written testimony in support of this measure.
Thank you, sir. Next, we have testimony from Albert Perez from Maui Tomorrow Foundation Incorporated in opposition. Testimony from David Bissell from Kauai Island Utility Cooperative in opposition. Testimony from Jody Malinowski of Sierra Club of Hawaii with comments. Testimony from Reed Yoshida, Waioli Valley Taro Hui with comments. Testimony from Charlene Schullenberg in opposition. Testimony from Bianca Isaki in opposition. Members, questions for our testifiers? Representative Morikawa.
Thank you, Chair. I have a problem because of KIUC's issues on this matter. There is a very big project that they have invested in my district, a hydro project that requires water. And the lease time of 30 years is an issue for them because I believe that they would need a longer lease perhaps to make that project work. And it is a very sustainable project that's going to benefit Hawaiian Homelands. So just the consideration of that part of it.
Would you want to seek any response or questioning of Mr. Hirokawa in that regard?
I think that would help. Mr. Hirokawa.
Just to, I guess, explain that particular part of the bill is that, we had discussions with the Commission on Water Resource Management, and, the 30-year, excuse me, the 30-year limit was based on the approach that, we would prioritize the resource, the management of the water resource. And we felt that leases beyond 30 years, given the sort of the further unpredictability of climate change models at that time, would make any longer leases, really not appropriate. That being said, I mean, we certainly are, aware and appreciate KIUC's concerns. I guess what I can say is that, I would just defer to the committee on that issue, but I think our bill addresses other significant issues that need to be addressed in the water leasing process. So if anything, I would say maybe address that one particular provision, but I would ask that the bill itself, with the other provisions be passed.
Yes, I agree with that part of it. Thank you very much.
Thank you.
Thank you, Representative Morikawa. Representative Kobayashi.
Going back to the prior question for DLNR. Sometimes one size does not fit all. Would there be any possibility of creating an exemption for certain entities? And the second question would be, what would be the process for extending beyond 30 years?
Under, I think, the measure that the proposed amendment we have contemplated, sorry, I'll answer the second part first, is that the idea is that the lease would end and they would just go through the leasing process again. Now, I would note that if the measure were to pass, as with all our amendments, with all our proposed amendments, there's a direct lease option. So it's not like you would necessarily go out for competitive bidding. But I think the idea is that, there would be a new environmental review after 30 years, and then, consultation with Commission on Seaworm, and the board would have the chance to, revisit that issue again, along with getting public testimony at the time of the lease ending. So you would get you would petition for a new lease and go through that process, but it wouldn't necessarily be the competitive bidding process. The second, I guess, or the first part of your question, I guess, is, I mean, if the legislature sees fit to grant exemptions, I mean, that's a pretty broad question. So I would say, if anything, I would suggest that it be, rather than certain entities, maybe certain uses of water. Like I know the DHHL bill exempts, traditional customary, like carol cultivation. That's certainly something that, we can appreciate that. So, something like that, I just would not necessarily apply to like parties themselves, but rather uses.
Mhm. I mean, in the one size fits all commentary, Sierra Club testimony talks about shortening maximum water license from 30 years to 10 years, which is, like a drastic difference.
I would say that, I understand where they're coming from, but, even if you were to pass the bill, I guess, as is, or whatever changes that, you folks make, but it doesn't necessarily make the process easy. It's still a very, even with the changes we're proposing, it's still a very complex process, a lot of public input, a lot of investment by the applicant into getting a water lease. You would need to do an environmental study. You would consult with DHL, get the water reservations every time you do a new lease. So, and a watershed management plan. So, 10 years may be a little short. I understand, where they're coming from, but it just seems to me that's a lot to invest for every 10 years. I think what we're saying is that we think trying to reach that, what we call like the sort of good medium, and 30 years, maybe, it's shorter, not as short, but gives them, lessee more time, but not 65 years. So that's why we kind of came up with what we thought was a good compromise for that.
Okay, thanks.
Thank you.
Thank you.
Other questions? Returning second question to Representative Morikawa.
For the department, so how did you come to 30 years? I understand what you just said, but can't you just make the determination in your department for a term to be determined by DLNR? Or is it that people don't trust that you can negotiate that reasonable length of time?
Well, the board has a discretion, and it would go through a public hearing. I think from what I recall when we discussed this issue was that the climate change projections after 2050 become very much more uncertain. So, you know, that's about 30 years from now. So I think that's how we came up with the number, was that, okay, if we start, you know, this bill gets passed and we start finalizing the leases, you know, that's that kind of, for lack of a better, that kind of like sweet spot that where, okay, they would end and we would maybe hopefully know more at the time about what the future will be in terms of the water resource. Now, you know, yeah, I mean, as an alternative, we could, you know, like I said, negotiate or draft a lease that could address it within the lease on a, you know, with respect to the individual applicants. That is possible, but we kind of felt that at least having it in the statute would maybe give assurances to the general public that, you know, there would be this, for lack of a better word, safety mechanism. But like I say, if it's going to cause problems for the applicants, I definitely would say, okay, the committee can, we would ask that the committee reassess that one provision rather than the whole bill.
Yeah, I understand. And that's why I'm worried that this language may lock it into that 30 years and not allow for that negotiation. So it's just a concern, but this bill has a ways to go. But thank you for at least noting that.
Thank you.
Thank you, Representative Morikawa. That's a valid concern. Other questions? Representative Kobayashi.
I would think you should look at the bill and related HRS so that it's clear that you seem to be moving from the term lease to the term license.
Yes.
So for instance, on page 1 of the bill, the first major paragraph of HRS chapter 171, you have the word lease at least twice, but you don't have the word license.
Mr. Hirakawa, would you like to give any comments to that?
Yeah,
Go ahead.
yeah, I'm sorry, I'm not addressing necessarily the specific discrepancy, but just kind of give some background. In consistent with the language in the state constitution, it uses the term water license, not water lease. So, you know, we felt that that was something to for lack of a better word, fix. The other reasoning behind it, more with the policy background, is that, you know, unlike a lease of land, we're not treating the use of the water as necessarily an economic or some kind of economic asset. You know, it's a right to use water for reasonable and beneficial purposes for ag or hydro or what have you. But it's not something like a lease that, you know, you can assign or some other economic asset. It's more just, you know, the right to utilize a public trust resource, but not,
No,
you know.
what I'm trying to say is that when you switch from the word lease, license, you gotta look at other provisions in HRS to make sure that that word license is then covered. Because in the first page of your bill, line 7 and 8, it says that the board may make provisions in the lease, comma, agreement, comma, or sale, comma, for the payment of just compensation to the surface owner. But I'm not sure whether the word license should be added there.
Oh, I'm sorry. Yeah, we should have added license, because just to 17158 covers mineral as well as water rights, and we're not necessarily changing anything with regard to like a mineral rights lease. You know, this is specifically for the use of water. So you're correct. Yes, we should probably add license or water license to that as well. Sorry.
Okay, but you know, you get the bill drafters to look at this again. Thank you.
Good point. Thank you very much, Representative Kobayashi. Questions? Representative Ganadin.
I note the appearance of Chair Isla, who was offline just briefly when he was asked for comments on this bill as well as the previous one, HB 501. I was wondering what the chair was thinking about with regards to our conversation on this bill, 1015, for the term time, 30 years to 10 years. And then also if he wanted to, if the chair would allow his comments on HB 501.
Thank you, Representative Gannon. And certainly you could ask questions of Chair Isla on HB 1015. So let's see if Chair Isla is available to respond. I see you. We don't hear you. Say something. I'm sorry. We still don't hear you.
Yeah. Shit.
And I think it's at your end, unfortunately. No, I'm looking at my IT people here and none of them, we can't.
Hear you.
Unfortunately, we cannot hear you. And
Yeah, I know.
Sign language, man.
Yeah, do you like 30 years? No, no.
Oh, sorry.
30 years is okay.
30 is okay. Okay, cool.
Okay, thank you.
Right on.
Ask
Thank
for
you
50.
for answering my question.
Yeah, it'd be good if we could solve this problem. We'd like to be able to hear from you, Chair Isla, but sorry from that. Okay, thank you for those questions, members. If there's no further questions, we'll move on. Okay. Next, House Bill 1007 relating to penalties for violations on certain state lands. We have testimony in support from Emma Ewan of DLNR. Ms. Ewan, if you're available, you have the floor. Please proceed.
Aloha, we stand in support. I'm Emma Ewan with Division of Forestry and Wildlife, DLNR.
Thank you very much, Ms. Ewan. We have testimony received from David Williams, Deputy Attorney General, providing comments. Members, any questions for DLNR? Nope. Okay, thank you very much. Let's move on to House Bill 1012. This is relating to rentals for public land leases. We have testimony in support from DLNR, Mr. Ian Hirakawa. Mr. Hirakawa, if you'd like to give testimony, please proceed.
Thank you, Chair. Members of the committee, Ian Hirakawa with DLNR Land Division. We stand in, I will stand on in support of, stand on our testimony in support of the measure and be available for any questions. Thank you.
Thank you. Thank you. That's all the testimony we have. Members, any questions? We'll move on. Next, we'll go on to Representative Kobayashi.
For DLNR.
Yep.
I don't understand the repealing after 2026. Is it that you intend to use this bill just for a short time or just for a particular case like Uncle Billy's Hotel?
I think the idea is to not just Uncle Billy's. I mean, you know, we would hopefully assist with the Banyan Drive projects, but also we have several, you know, major projects such as our proposed industrial and business park out in Pulehunui, Maui, and our East Kapolei TOD development project, and you know, those are looking to come online, or at least, you know, hopefully make some progress on it within the next few years. You know, I think this was just seen as my understanding is it might be just seen as a pilot for now, and hopefully, if you know, it could be extended depending on how well it works. But I think it was just more to, you know, to say, okay, we don't want to just, you know, we want to have some sort of it's a pretty radical departure from what is currently in the statute, so we want to give it a chance to actually put it into to practice and see what happens.
Okay.
Thank you. Any other questions on this measure? If not, it appears that Chair Isla is now figured out his audio. So with your indulgence, members, I'd like to offer him an opportunity to respond to Representative Ganadin's question, which was on HB 1015, and is specifically about the term 30 years. Chair Isla, please proceed.
Thank you. We've moved like 3 computers around to get to this point. So thank you for the opportunity to come back in and provide answers to the questions. So again, the 30 years is fine with us. The main purpose for 501 and this bill, our testimony, is to provide sort of a suggestion for the way appraisals are done. Right now, no one knows how to do an appraisal on water in the state of Hawaii because our situation is so unique. So we came up with sort of this option, which is a logical way to do it. We understand that we understand that it's new and that it is causing concern amongst many water users at this point. But absent of some direction, just having an appraiser appraise water with its unique history in Hawaii is going to be a challenge. And our concern is that because the department is short of funds, and this is a major contributor to our rehabilitation fund, that we would miss out on an opportunity for a reasonable return to the department for its beneficiaries. So I thank you for the opportunity to testify out of turn.
Absolutely. Your input is important. And that's part of why I wanted to make sure we heard HB 501 as well as HB 1015 and had this discussion, because it is an opportunity for us to be educated by the Department of Hawaiian Homelands about this alternative approach, albeit it may need more work. But the first step is really to help to educate us. Let me open it up to other questions from members now that Chair Isla is available. Any other questions for Chair Isla? Representative Ganadin.
Just a follow-up. So I saw somewhere in, it might have been 501, a single appraiser. So that's a single human being to do much of these appraisals, or is that what you're envisioning?
The appraisal process would be that the Department of Land and Natural Resources would do an appraisal. I believe if someone objected to that appraisal, then the objector to that appraisal could get their own appraisal. And then the process would be, if the two appraisers cannot come to an agreement, then there is a process for arbitration, and a third appraiser would be brought in. That's how they do it on the land side right now. And I would assume that that's how they would do it with water now, because it's part of their statute.
Other questions? Representative Morikawa.
Hi, Mr. Isla. If going back to my KIUC project, because I guess there's no benefit for the use of the water for DHHL, but it was negotiated, the access to water on your lands up in Koke was negotiated into the project. So as to give, homesteaders that access. So is that something that would also, in a project like that, would benefit Hawaiian Homelands instead of an outright payment?
Yes, other forms of payment could be included in the contribution based upon the 30% of revenue off of water licenses. So as in the KIUC and Waimea water mediation, that was part of the process, and it certainly could lead to creative opportunities for the department to receive its fair share.
Okay, if you can take that into consideration, that's fine. Thank you.
Thank you, Representative. Other questions for Chair Isla? I would urge members to really take a look at 501. It's the first time this has really been discussed, and it is an important issue. And then, of course, under 1015, the DLNR's testimony has their suggestions as to what should be amended. So take a look at those as well. Okay, any further questions on these matters, on these bills? If not, we will proceed back onto the order of the agenda that we had interrupted. Let's see. We're now moving on to House Bill 1016, which is relating to the taking of marine life. And for this measure, we have received 10 testimonies, all in support. First one from DLNR, Mr. Brian Nielsen of the Division of Aquatic Resources. Mr. Nielsen, the floor is yours.
Aloha, Chair Tarnas and members of the committee. We stand on our written testimony in support and are available for questions. Thank you.
Thank you very much. Next, testimony in support from Ann Iwasaki with Ice Partners, LLC. Next, testimony in support from Miley Kim, POP Fishing and Marine. Testimony in support from Kay Castro, Vessel Management Associates, Inc., in support. Brooks Takanaka, United Fishing Agency, in support. Eric Kingma, Hawaii Longline Association, in support. Roy Morioka, testimony in support. Shyla Moon, testimony in support. John Kaneko, testimony, he says he's from the Hawaii Seafood Council, and that testimony is also in support. And then Joshua DeMello, testimony in support. That's all our testimonies today, members. Any questions for DLNR? If not, we'll move on. Thank you very much. Testimony, let's see, we're moving on to House Bill 1018 relating to lay nets. We've received 3 testimonies, all in support. First, from Brian Nielsen, DLNR, Division of Aquatic Resources. Mr. Nielsen, the floor is yours.
Aloha, Chair. We stand on our written testimony in support. Thank you.
Thank you very much. Next, we have testimony, Bianca Isaki in support. Joshua DeMello in support. That's all the testimony we have. Members, any questions? Representative Kobayashi.
Question for DLNR. It seems that the penalty is petty misdemeanor only. I would think that in some cases you might want a higher penalty. Any comments?
I'm going to ask our program manager, David Sakota, to field that question.
Good morning, thanks. David Sakota with DAR. We have, a range of penalties. I think the petty misdemeanor is appropriate for, general lay net violations. We do have higher penalties associated with protected species. And I believe we're also looking at amending some of our criminal penalty statutes to allow for per specimen charges rather than per violation. And that would enable us to, collect higher fines for instances where a lay net may be used to take multiple specimens that are higher value than, I guess, the statutory fines as they currently exist. But we feel like petty misdemeanor is appropriate. We even face challenges in court with judges tossing out fishing cases because they feel petty misdemeanors are a little harsh for fishing violations. So we don't want to increase it beyond that.
But the petty misdemeanor seems to apply to the entire chapter, not just lay nets.
Yes, and that chapter would be for a violation of things like bag limits, size limits, gear restrictions, any rules adopted under this chapter. And we feel that a petty misdemeanor is the appropriate level of penalty.
Okay. Thanks.
Thank you for your question, Rep. Kobayashi. Other questions? Rep. Ganadin.
To the Mr. Kobayashi, can you explain if there's any federal criminal rules for similar conduct? And you mentioned specific instances of takings. So it's like if let's say you find a defendant who is in prospective violation of this rule, who is also taken an endangered marine mammal or something like that. would they be facing both the state charge and the federal charge?
So I believe they would be, they could face federal and state charges. That's up to, I guess, the enforcing officer. I know for our aquatic resource penalties, we have civil violations that are higher for protected species that are $5,000 per specimen taken versus the maximum for non-protected species or non-endangered species is $1,000 per specimen. But again, those are for our administrative penalties. They don't apply to our criminal penalties.
Follow-up question, Rep. Ganadin?
Yeah, would that lead to somebody losing their license entirely? Because this bill does mention section 188-70 on page 3. I didn't have time to review that section. So could a multiple, like somebody who violates multiple times, have their license revoked or not be able to reapply for a license or something like that?
Yeah, thanks. So for fishing, generally, we don't require a license. If it's a commercial fishing, then we require a commercial marine license, and those can be revoked for failures to comply with the terms and conditions. Specifically for this laynet permit, we're requesting the authority to revoke or suspend or withhold permits for non-compliance.
Thank you.
Thank you, Representative Ganadin. Other questions, members? Okay, thank you very much for those questions. Let's move on to the next measure. House Bill 1020 relating to adaptive natural resources management. We have testimony in support from Brian Nielsen of DLNR. Actually, there's 2 testimonies from DLNR. Perhaps, Mr. Nielsen, you could speak to both. You have the floor.
Yeah, thank you, Chair. We stand on our written testimony, and we did revise our testimony slightly. That's why there was 2 testimonies submitted. So we're standing on the second testimony that provides some amendments, additional amendments to the bill as our testimony today. So thank you.
Please take a moment and explain what that is, since you're going to be asked a question about it anyway.
Yeah, David, do you want to explain that?
Yes. Again, David Sakota with DAR. So the proposed bill, as originally written, would have eliminated our rulemaking authority for things like bag limits, size limits, gear restrictions, and transferred those to this adaptive management procedure through the board. That may not be desirable in all cases. There may be, rules that we want in place permanently. So we would propose keeping the existing Chapter 91 rulemaking authority and not touching those sections that we've highlighted in our testimony, but just adding the authority for adaptive management for those particular types of rulemakings.
Okay, thank you. Let's move on to the next testimony from Kim Koch, individual in opposition. Testimony is in your packet to read. And testimony with comments from Joshua DeMello. Questions, members of DLNR?
Yeah,
Representative Morikawa.
thank you, Chair. I guess this would go to DAR. As I'm understanding this, as you guys are making changes to more about conservation, correct? So you're getting rid of bag limits and all of that. You're just gonna determine what a person can catch depending on environmental or conservation stuff.
I think this.
If I may, Rep. Morikawa, take a look at the testimony for their recommended changes where they actually want to keep all of that.
I'm not seeing it, sorry.
It's the second testimony that they had sent in, which basically says they want to keep that authority to do all of those matters by rule.
Okay.
But then they want to add that they can also do, it's available to do it by decision of the board. So I think that's what they're asking for. If I turn it back to you, Mr. Nielsen or Mr. Sakota, if you want to confirm that, go ahead.
Yeah, I confirm that. That's correct. So this is just to give us the flexibility to make small tweaks to bag limits, to address environmental conditions or resource conditions. It would sunset after 2 years, but it just gives the department a little more flexibility to address things that come up quickly in our resources that otherwise would take a lengthy process to go through the full Chapter 91 process. Yeah.
Okay. It's just that my big worry is that through these hardships of COVID, people are going out to fish, to bring food to their table, not understanding a lot of the restrictions, the rules, and so they may be violating these rules and end up in court. So I'm just very concerned about that, and I hope that the department will make their rules thinking about sustenance, not just about the depletion of the supply, unless you had real good data about that. Thank you.
Thank you, Representative Morikawa. Other questions? If not, let's move on to the next measure. House Bill 753 relating to school impact fees. We have testimony and support from William Isla, Chair, Department of Hawaiian Homelands. Chair Isla, the floor is yours.
Good morning. Thank you very much, Chair. We strongly support this measure. We do know that the Department of Education is concerned about a precedent that it may set. I see it as sort of reversing a precedent that was set on the department in terms of additional monies that could be made available for the development of lots. We have many schools, charter schools, and a few public schools that are on DHHL property right now that are charged, the charter schools are charged gratis. So we just feel that this brings back a nice balance for the department and would allow us to retain funds to be redistributed in other development areas.
Thank you very much. Next, we have testimony from the Department of Education, Randall Tanaka, giving comments.
Hello, Chair.
The floor is yours. Go ahead.
Hello, Chair Tarnas. We stand by our testimony. I'm Randy Tanaka with the Department of Education, Office of Facilities and Operations. We understand the intent and appreciate the intent of the bill. So we stand by our testimony and support for it. Aloha.
Thank you very much. Members, any questions of our testifiers? If not, let's move on to the next measure. That would be House Bill 1023, relating to a non-resident recreational marine fishing license. We have testimony and support from the DLNR. Mr. Brian Nielsen, the floor is yours, sir.
Aloha, Chair. We stand on our written testimony and support. Available for questions.
Thank you. Next, we have testimony from Joshua DeMello in support. That's all the testimony we have before us today. Questions, members? If not, let's move on to the last measure on our agenda. House Bill 1150 relating to fishing. And this actually requires both a resident and non-resident fishing license for recreational fishing. So it's slightly different than the 1023, which is only non-resident. 1150 is offering the idea for both resident and non-resident, non-commercial fishing license. So we have testimony received from Brian Nielsen from DLNR. Mr. Nielsen, the floor is yours.
Thank you, Chair. We stand on our written testimony and support. Available for questions.
Thank you. We have testimony in opposition from the Native Hawaiian Gathering Rights Association, Mr. Godfrey Akaka. We have testimony in opposition from Clayton Kubo. Testimony from Edward Clark in opposition. From Marino Carrera in opposition. From D. Uilani Kiaha in opposition. From Roy Thomas Sokolovsky in opposition. And from Joshua DeMello in support. Members, any questions?
Yes.
Representative Kobayashi?
For question for D. Lenore. Does this mean that if you are fishing in the Alawai Canal, you need a license?
You're not a resident.
Yeah, I would assume you would need a license. The Alawai Canal, I think, it is, I guess it would depend where you are in the Alawai, but I would consider that marine waters. It is an estuary. So I believe you would need a license to fish in the Alawai.
What about fishing season up in Kokee, Kauai?
So right now to fish in Kokee, we already require a freshwater fishing license. And I believe that license is $5 a year to be able to partake in the trout fishing up there. So right now you would currently need a license to fish in Kokee.
Thank you.
Representative Morikawa?
Thank you. First of all, I know that this is going to be a nightmare to try to enforce because there's going to be so many people that will just take out a fishing pole and go fishing, and they're in violation because they do not have a permit or a license. So I have a big problem with this because of that. There will be too many, especially in Hawaii where we're surrounded by waters. Fishing is many of our lifestyles. I would love to see a voluntary program where if you want to buy a license, go for it. Freshwater or salt, whatever it may be. But forcing this on anyone who just decides to go fishing is something that I just cannot support. And also I would recommend that if there is a depletion of a species, why are we not looking into replenishing that species instead of having people go through licensure to catch things? I mean, if there are a lot of huge stock like trout, if you can grow the trout up in Kokee, then that's great, and then the license kind of helps that program, but it's more of a voluntary basis. So sorry, Chair. But
Oh, no, that's
not so much a question as comments.
And no, that's very appropriate, and I appreciate that. We all have received phone calls and emails from our constituents, and the whole reason I'm hearing this bill is for us to hear from the fishing community, from our constituents on this. So it's very appropriate that you bring up your concerns.
Thank you. Thank you, Chair.
Questions? Representative Ganadin.
For Mr. Nielsen, should this bill go forward, is there a plan to make this licensure easily accessible to individuals, say online? What would be the timing to get it? Like, let's say you wanted to go fishing in the afternoon. Could you apply in the morning and then get your licensure like on your phone or something? The way I know the county is doing for, say, pop-up tents on beaches. Would that be even possible?
Absolutely. We've already developed an online system for our commercial marine license. You can also get our current freshwater sport fishing license online. So we'd be looking at a full online system for this licensing program. And even folks that maybe they don't have computer access, they could come into the local office and type in their information to the computer in the office and get a license that way. But we would be looking at a full online system for this that, somebody could obtain a license, in a matter of, 10 minutes or so to process all their information.
Okay. And to be clear, you're not pursuing any criminal penalties for a lack of a license?
That's a good question. I don't know, David, are you still on? Maybe you can address that question. If there's criminal penalties.
Yeah, I think that's in, trying to look at the sections. I can't recall if it's in this bill or the non-resident license bill, but I think that's a good idea. for licensing type violations. I don't think that would be appropriate for criminal penalties unless, you know, it was like an egregious, you know, repeat offender.
Well, I'm noting, let's see, on HB 1150, page 7. Let's see, any person who has any outstanding criminal administrative fines.
Rep. Ganadin, you'll need to speak more clearly
Okay,
into the microphone.
I'd like you to clarify, page 7, line 14. Any person who has any outstanding criminal or administrative fines shall not be eligible to obtain an, I'm paraphrasing, obtain a new non-commercial freshwater and marine fishing license. So a criminal fine could be anything as low as just a violation, which would be like the equivalent of I suppose a parking ticket or a moving violation in a vehicle, all the way up to you know, a petty misdemeanor, which is an arrestable offense. So how do you foresee this playing out if an officer comes up to somebody who doesn't have a license to show them immediately?
So I think this provision speaks to the issuance of a license. So if someone has been convicted of a violation or has an outstanding administrative fine that they have not paid yet, that they've been already adjudicated as required to pay, we would not issue them a new license until they've taken care of their penalties and fines. It doesn't so much speak to the enforcement when an officer, you know, goes up to someone in the field and inspects if they have a license. Of course, they would need one, and they would need to display that to the officer if they're fishing.
Thank you. Other questions? Vice Chair Branco, yes, of course.
The question is for Mr. Nielsen. In our community, we're very fortunate that we have wetlands, a bay, as well as beaches. As you are aware, sometimes our rivers are opened up and they drain into the beach. Would this be covered by that? That's when the fishermen come on and actually fish on the bridge when the water becomes brackish and changes.
Yeah, I guess I'd have to look at the bill some more, but I would assume that that is considered marine waters. You know, an estuary is considered marine waters and would be covered, but you know, maybe there needs some language just to clarify that.
Thank you.
Other questions, members? Yes, of course, Representative Morikawa.
Thank you, Chair. Just because I'm new to this committee and I haven't read all of the laws, but can someone explain to me what the customary rights protected, traditional and customary rights are? It's on page 7.
Mr. Nielsen or Mr. Sakota, could you please respond?
Yes, hi, thank you for the question. I'm not an expert on traditional and customary Native Hawaiian rights, but it is protected by Article 12, Section 7 of the Constitution. My understanding is that it can be asserted as a defense for if a defendant is charged with a violation of some kind of law or regulation. But there's certain, I guess, questions that the court looks at to determine whether the right is an actual gathering right, and that includes if the person is Native Hawaiian, if it's a practice that's been established prior to, I believe, 1876, if it's in the ahupua'a that they reside or that they have ties to, if it's for non-commercial purposes, you know, and I believe the state does have the constitutional right to establish reasonable regulations, and so they also balance, you know, the interests of the state in having certain regulations versus the Hawaiian gathering right. And also if there's a way for the person to exercise that right through like a state permit or licensing process, then they need to go through that process if it's available. I'm sure there's a lot more details, but that's kind of a general overview of that.
Okay, thank you. Because I'm just hearing from people that if I'm Hawaiian and my family has been doing this for many, many years, I have the right to go out and catch whatever I want to catch. That's what I'm just information. I never researched it, but thank you for that explanation.
And thank you for bringing that to the floor for discussion, because that is a very important matter. Absolutely. Any other questions, members? I really appreciate the debate. Yes, Representative Kobayashi.
Question for DLNR. In Kailua, on either end, there, I think, man-made canals that open up into the ocean. So those, I think, would be considered fresh water. So this bill would now require people to get a license for non-commercial fishing in those canals. Is that correct?
Yeah, I would have to look at the bill more closely, but you know, if that's not, you know, defined well in the bill, maybe that's something to look more at, just to make it clear for the enforcement officers that would have to go out and enforce compliance of the licensing system, that, you know, there's no you know, question of whether you need a license, whether it's brackish or fresh or marine, you know, that it's you know, not a clear line there. So that is a good question, and something that we should, you know, take a closer look at if this bill moves forward.
Thank you.
Thank you, Representative Kobayashi. Any further questions? This discussion is very helpful. Appreciate it. All right, there being no further questions, I appreciate the testimony today from everybody. I would like to adjourn this and go into decision making. Reconvening for decision making of the measures that we have just completed our hearing on. And I would like to take it from the top of the agenda. My recommendation for House Bill 203 is to pass as an HD1, defect the effective date, January 1st, 2050. Members, any discussion? Representative Kobayashi.
Are you going to keep the dollar amount?
I will remove the, yeah, thank you. I should remove the dollar amount and put it into the standing committee report. Good reminder. Thank you.
Blank dollars?
Blank dollars.
Thank you.
And I will put the dollar amount into the standing committee report. Thanks for that suggestion.
Could this be a CIP from someone? Or it has to be a bill?
This is a bill that we are hearing today.
Okay.
Thank you. Any other questions? Yes, Representative Kobayashi.
I would like to suggest that maybe language be added so that the language added would be not limited to.
Not limited to
Not
what?
Right now it says include water storage structures, et cetera, et cetera. But it seems that with Office of Hawaiian Affairs owning that particular site around the birthing stones, that there might be need to make some improvements such as entry, et cetera. Because right now I believe that that's an entirely dirt road with very little signage and very, how would you say, unimproved access to the highway.
Yeah.
Thank you. May I suggest the language and related improvements?
Okay.
Is there going to be access during construction? I mean,
That's, so I think, and related improvements would, I think, suffice. And if it's not, then in the next committee, the department can come back and request some modifications. So just to cover it again, an HD1, defect the effective date to January 1, 2050, delete the appropriations amount and put that into the standing committee report, and then add the words and related improvements after the description for which the money will be spent. Okay, any further discussion? Seeing none, Vice Chair, please take the vote.
The recommendation of the chair is to pass House Bill 1 with amendment.
House Bill
Oh, excuse me,
203.
Excuse me, House Bill 203 with amendments. Chair and Vice Chair vote aye. Representative Ganaden.
Aye.
Representative Kobayashi.
Aye.
Representative Kong.
Aye.
Representative Morikawa.
Aye.
Representative Ono. Aye. Representative McDermott, excused. The measure passes.
Thank you. Moving on, House Bill 544. My recommendation is to pass with an HD1, defect the effective date, January 1, 2050, delete the Department of Land and Natural Resources and insert University of Hawaii. And then in the standing committee report, add the language that the estimated total cost would be 1.36 million. That's my recommendation. Discussion, members?
That amount is gonna be in the bill?
No, standing committee report. Yeah, standing committee report. Any discussions?
I don't know how standing committee reports work, but we're just speaking to the next committee.
So the standing committee report goes with the amended bill when it goes to the next committee, describing what we've done in this committee and any other comments that we wish to include. So that's where the language will go. It helps to provide additional information to the next committee.
Yeah, I'd just like to note the testimony discussing the use of the equipment for a teaching telescope that is in another bill that is not before us today. So should this one move forward and the other one not move forward, it would be a shame to take the thing apart and trash it if it's still usable.
So you're requesting that we include some language in the standing committee report to note that this is what the intended use would be for the telescope as a teaching telescope in another location.
That's right.
Okay, I will accept that as a friendly amendment to the standing committee report. It won't be in the bill itself. It'll be in the standing committee report.
Thank you.
Okay. Any other discussion, members? If not, Vice Chair, please take the vote.
The recommendation of the chair is to pass House Bill 544 with amendments. Noting the excused absence of Representative McDermott, is there any reservations? Any no votes? The measure passes.
Thank you. Moving on. House Bill 501. Thank you very much. And I'm so glad that Chair Ilo was able to have the opportunity to talk to us about this bill. I urge you to read it through more. This is the first opportunity for us to hear what they're proposing. It's innovative. I would say we're not quite ready for it. So I'm going to recommend we defer this measure. But I urge you to take a look at DEHHL, their testimony and this measure, because we will be having discussions about this in the future, I'm sure. So my recommendation is to defer House Bill 501. Next measure, House Bill 1015. My recommendation is to pass with a House Draft 1, defect the effective date, January 1, 2050, and insert the language in the DLNR testimony that we have before us. Members, any discussion?
Yes, Chair, I'm gonna have to go with reservations only because of that project I have in my district. Thank you.
Absolutely right, and I appreciate that. This is the middle ground. It's not the 10 years some wanted. It's not the 60 that others wanted. This is the middle ground. But I appreciate that. So we'll note your reservations when we vote. Thank you, Representative Morikawa. Representative Kobayashi.
Could you add something about technical non-substantive amendments to possibly accommodate the word license in other sections of this and
Thank you.
This chapter.
Good point. And you did mention one, and I had made a note that I should have said. So thank you for reminding me. On page 1, line 7, add the word license and technical non-substantive amendments in line with that throughout the bill. Thank you. So this would be HD1, defect the effective date to January 1, 2050, add the DLNR language from their testimony and other technical non-substantive amendments. Further discussion? If not, Vice Chair, please take the vote.
The recommendation of the chair is to pass House Bill 1015 with amendments, noting the excused absence of Representative McDermott, noting the vote with reservations of Representative Morikawa. Is there any others with reservations? Any no votes? The measure passes.
Thank you very much. Moving on, House Bill 1007. My recommendation is to pass as an HD1, defect the effective date to January 1, 2050, add the language recommended in the testimony from the Attorney General, and make some other technical non-substantive amendments. Members, any discussion? If not, Vice Chair, please take the vote.
The recommendation of the chair is to pass House Bill 1007 with amendments, noting the excused absence of Representative McDermott. Is there any reservations? Any no votes? The measure passes.
Thank you very much. Moving on, House Bill 1012. My recommendation is to pass as an HD1, defect the effective date to January 1, 2050, and make technical non-substantive amendments. Discussion. Seeing none, Vice Chair, please take the vote.
The recommendation of the chair is to pass House Bill 1012 with amendments, noting the excused absence of Representative McDermott. Is there any reservations? Any no votes? The measure passes.
Thank you very much. Moving on, House Bill 1016. My recommendation is to pass an HD1, defect the effective date, January 1, 2050, and make technical non-substantive amendments. Discussion. Seeing none, Vice Chair, please take the vote.
The recommendation of the chair is to pass House Bill 1016 with amendments, noting the excused absence of Representative McDermott. Is there any reservations? Any no votes? The measure passes.
Thank you very much. Moving on, House Bill 1018. Recommendation is to pass as an HD1, defect the effective date, January 1, 2050. Discussion. Seeing none, Vice Chair, please take the vote.
The recommendation of the chair is to pass House Bill 1018 with amendments, noting the excused absence of Representative McDermott. Is there any reservations? Any no votes? The measure passes.
Thank you very much. Moving on, House Bill 1020. My recommendation is to pass as an HD1. We will include the recommendations from the DLNR and defect the effective date, January 1, 2050. Members, discussion. Seeing none, Vice Chair, please take the vote.
The recommendation of the chair is to pass House Bill 1020 with amendments, noting the excused absence of Representative McDermott. Is there any reservations? Any no votes? The measure passes.
Thank you very much. Moving on, House Bill 753. Recommendation is to pass as an HD1, defect the effective date, January 1, 2050, and make technical non-substantive amendments. Discussion, members. See, Representative Ganadin.
Thank you, Chair. I'm noting that this is not appearing before the Education Committee. I think that there would probably be a robust conversation were it assigned to that committee. It's going straight to judiciary after this. So, especially in light of a major deficit, the state is facing other issues regarding payment for development by the Department of Hawaiian Homelands. I feel like we could have a more robust conversation in that committee, but I'm not sure. No.
I appreciate that observation.
Didn't Randy Tanoe testify for the DOE?
Yes, indeed. DOE did testify in support.
Oh, just
okay.
I appreciate the observation about the referral, but the referral is as it is. And thank you for that observation, though, Representative Ganadin. Okay, HD1, the effective date, and technical non-substantive amendments. No further discussion. Vice Chair, please take the vote.
The recommendation of the chair is to pass House Bill 753 with amendments, noting the excused absence of Representative McDermott. Is there any reservations? Any no votes? The measure passes.
Thank you. Moving on, House Bill 1023. Recommendation is to pass as an HD1, defect the effective date, January 1, 2050, and make technical non-substantive amendments. Discussion. Seeing none, Vice Chair, please take the vote.
The recommendation of the chair is to pass House Bill 1023 with amendments, noting the excused absence of Representative McDermott. Is there any reservations? Any no votes? The measure passes.
Thank you very much. Last measure on our agenda, House Bill 1150. The chair would like to express his sincere appreciation for the lively debate that we had here in the committee, and express my appreciation to the testifiers for their testimony, and to the many who called us on the phone or sent us emails, and those watching today on YouTube. I introduced this measure so we could have this robust discussion about something that we need to try to figure out. Currently, we do not have data on how many fishermen and fisherwomen there are out there. And I expect that overall, recreational fishing may in fact catch more fish than commercial fishing in this state. We just don't have the data. And this measure was intended to have a discussion about whether this in fact would be a means by which we could gather data, because it is only with good data and good science that we will have the ability to manage our fishery to make sure there's always fish to catch, because that is an important part of our quality of life. It's an important way for us to provide food for our table, and it's part of our trust responsibilities here. So my recommendation is for us to defer this measure, and I will certainly take under advisement all the comments that we received and be working with the Department of Land and Natural Resources to figure out a path forward so we can figure out how to better manage our fisheries here in the state to make sure there's always fish to catch. There being no further business before us today, I thank the members for their indulgence today and the lively discussion. This hearing is now adjourned.